process.
Okay, kind of capturing what Steve's saying, state divisionaries should play an active role in there in the process because they have a good understanding of how the systems are operated, and certainly we're very familiar with the aspects of the operation of water rights. And I guess to some degree you're suggesting that for those who are the smaller water users who don't have the resources to represent themselves, that certainly could be a role that the state takes on. So did I miss anything capturing that? I think there was over here. Yes.
When it comes to large water users have vesting, definitely not in decades of vesting. Ensuring that are there and replace each other. So as far as the state can come in and protect water users from each other, the closed water users have the best because the state doesn't have and that's going to be us. I do like the idea of smaller, share what you don't have
I appreciate the comment. If I capture it, I think there was she made a statement that as far as large water users go, that it probably isn't proper or necessary that the state plays a role in there in terms of quote, representing or protecting the interest on behalf of large water users, but maybe suggesting she might agree there might be a possible role for the state for the smaller water users that may not have the resources available to defend them. And I guess this gets into maybe a nuance of the thing and saying, well, in there actively participating, not defending them as far as representing them, but maybe just identifying the issues and trying to take a lead in making sure those are resolved through the process, as opposed to just identifying them in consultation and stepping back. As far as if we think there's the smaller water users out there that are identified that are being impacted by this, maybe just a little bit on that. Do you think that would require, or if those water users who think they're being impacted out there, the small ones, somehow have to engage with us and identify, hey, we don't have the resources, but we're being impacted. Can you play some role? Because I think what we've been accused of sometimes saying, well, you guys say you're protecting the system out there, you're protecting the water users, but who are those identified users? We just say they're out there. Because we say, well, there's a call on the system, so somebody's being impacted whenever they're short of water. So I'm just curious because right now, there may not, sometimes we may be contacted smaller water users say, hey, this is going to impact us, and so we're aware of it. But I'm curious your thoughts on that.
That's the case, right? That's not good. There's already lots of competition in We're doing a pretty good job of being about without even the state. So, and that's size.
So, if we catch real quick, I think you're saying that as far as the case specific to Clear Creek, because of the large users up there, I'm just trying to recapture folks online that didn't hear the question and comment. Maybe because there are the large users up there have the resources that they are certainly representing their clients' interests as far as determinations of historic consumptive use and all the scientific engineering aspects are there that certainly I think you were suggesting because of the limited resources state that isn't a role that we may need to play in that process and actively engaged in the scientific engineering aspects of that. Now maybe there's administration issues that may be at stake there. I can still think people are suggesting if you say we can't administer something, then we think we probably have a role to speak up in that process. Right.
Yeah. I appreciate your position of injury. I have several cases where it's come on that, where there's an impact that a lot of people can quantify. There's a party that we identify to be impacted. And that includes stakeholders such as tax card, having end users that identify some principles or actually do. So I think that it's very important to identify actual quantifiable issues to parties as the appropriate goal, but we generally expect the idea of some Stanton junior user or somebody that just might be out there that has never proposed. I don't believe that's appropriate.
The comment was that he thinks that the proper role of the state is to get in and identify quantifiable, actual quantities of what the injury or impact would be to a particular specific water user, and as opposed to just some generalized or I think use your word phantom or perceived impact or injury that may be out there to a water user. So it's, I think the components there is you have to identify the specific water user that's being impacted and what that magnitude of that impact would be. Is that a fair characterization of your comment?
Yeah, I mean, how can we solve the problem? How can we protect the user?
Okay, thank you. Please, and I'll get you right back here. Go ahead.
Dick, I just have a few questions. I mean, I think it'd be helpful if you could explain a little bit more the sort of process that your office and the division offices go through to determine whether the consultation process is going to be a sufficient way to address the state's concerns or whether a statement of opposition is warranted. And specifically on administrative issues, to what extent you guys are consulting with the water commissioners that are going to be responsible for administering a particular decree in determining, whether those administrative issues warrant the state filing a statement of opposition. And then for the injury issues, to what extent is the state consulting with the parties that they identify as being potentially injured and addressing their concerns and using that as a gauge to determine whether the state should get involved as a party?
Yeah, no, great question. The first one was about our role in the consultation process and what happens when issues aren't addressed and what causes us to maybe get into a case or oppose a case. And again, it gets back to some of these things. Some of the things we've identified up front that are clearly like if there's a contact issue that we think is out there, some large issue that has statewide implications and policy issues. Now, those may come along infrequently, but there are oftentimes those. So I think there are times when we see those clearly up front that we need to get into a case. As far as one of the struggles we've had in this consultation process, we've tried to make them very robust. I mean, the division engineers do work with their staff closely, all the way down to water commissioners. They all get field inspections, they get input from the staff on every one of these applications come through. That's very clear. That's our role. The legislature's identified that's what we have to actively do. And so we identify those, and we may identify all these issues. And if you know that this consultation is a summary of the consultation with the referee, so when the DE submits that to the court, it doesn't break down, these are the water referee's concerns, these are the division engineer's concerns. It's a collective summary of the consultation that occurred between the referee and the division engineer. And so sometimes we've been accused of, well, you've got legal issues in there. Why are you guys raising legal issues? You should just be dealing with administrative issues. So part of what we're trying to get through this process too is in that consultation where we've got this combined input of the referee and as they go through that process, And if the referee is taking that consultation and using it and saying, hey, when they see a proposed decree come in or and say, if you address all these concerns in the consultation, let me just presume for the moment that that's the standard that the referee needs to abide by, saying, hey, you got to address all these concerns in this consultation, or you're not getting past go, I'm not going to enter a decree, or it may get referred to the judge. We have to tell you that that's not consistent across every division of the state. There's not some referees who will take that and necessarily embody everything that's in that consultation. It may be a lot of the issues we just raised and maybe doesn't really reflect any of the referees. So if this is where we struggle in this thing, if we would advocate that the courts obviously have a role in this process of doing of making sure that these decrees are entered, they meet all the legal standards and prevent injury. But if we're identifying issues that we think may be legal issues, injury issues, administrative issues, and they're not being addressed, then what do we do? That's where we oftentimes then we may file a motion to intervene if we didn't get in before. Then we get accused, well, you're taking the second bite of the apple. Why didn't you file a opposition up front when we saw those issues? So these are the things we're trying to work through in that process. So it very much involves working with the referee in each of those divisions, ensuring those things are addressed. So I think I've kind of covered your first 2 points. Now, again, on your third one about injury, could you rephrase that and make sure I remember the question?
Just to what extent is the state conferring with the people that it's identifying as potentially being injured before it's addressing those issues in either the summary consultation or a
Probably not the best one to speak to that because I'm not doing it at that level. We've got some division engineers and others who are more actively involved in that from Division 1. I don't know, is Dave or Mike somebody here from Division 1 that want to get questions about how active do we get involved working with the water users when there's identified injury issue. We identify it or they come to us as an injury. I don't know if someone can help me out that's in Steve, maybe you're here too from Division Engineer from the Arkansas Basin. Steve, you want to comment on that question?
United States very relying on our human knowledge and experience.
I think I'll capture what Steve just said. I think he indicated we don't actively engage with those users on there that from our experience and that we can quantify if there's an injury occurring that we feel we can identify that in consultation or a statement of opposition that it doesn't necessarily require us to have, or it has not required us to be actively engaged in. But that's why we're probably here to hear some of this. And should that, if we are going to take a position on that, whether it's to represent small users or something other than that, should there be some higher level of engagement there than what Steve characterized? I don't know if anybody from Division 1 would want to respond and characterize any different than that. Certainly all our divisions try to be consistent in our application law, but certainly every division. I see Dave in the back now. I don't know, Dave, if you wanted to.
He was tying his shoe.
I will say we do get unsolicited when we're in that process. So at least in Division 1, we tend to get unsolicited input more than we have.
Dick, can I just make
Yes.
2 follow-up comments on the injury thing in terms of the small versus large water user and drawing some line there and saying, if the case is a small case by some benchmark, then the state should get involved in every one. I just make the comment that small water users are applicants too, and so having the state just filing a statement of opposition mechanically in the case because it fits certain criteria is a burden on those folks too. So there are times when they're trying to do things on a limited budget as well. And then for the administrative issues, I would just mention that I've been part of cases where administrative issues have been identified, but then in talking to the water commissioner in that particular case, the water commissioner kind of takes the position that, well, this is sort of the way I've administered things, and yet the division or the state office is raising issues with that type of administration that's going on at more the local level. And so there seems to be sometimes a disconnect between the way the water commissioner is doing things out in the field and the way things are being administered in a particular area, and some of these issues that are labeled as administrative issues that are being addressed by the state in some cases.
Okay. The two additional points were made about the small users too, or applicants in cases, and he was cautioning against the state maybe just developing some fixed criteria about getting into certain cases on quantities of water or something that maybe that can be a burden certainly to those users, applicants who are small users who obviously have limited resources, and that create a real burden. And then you were commenting about the maybe somewhat of a disconnect in your discussion with the water commissioner about how locally the administration is going on, and then maybe what is ultimately reflected in consultations or statements of oppositions that may come out from the state division engineers. Is that a fair characterization?
That's right.
Okay. I'm back here, and I'm going to wrap up the last couple of things. So, yeah, go ahead, please.
Yeah, so I was speaking about the state rather than small. My question is, we're talking about limited states. That's why the state has to bear non-qualified injury on small. I mean, is it not worth it then? Want to specify that?
So the questions again along the lines of your comments regards to, you think, suggest again, like one or two other folks about the state may play a role in representing the small water users. And then I guess I'm not clear about this question about the quantification and how it impacts our resources, because I guess from a general standpoint, whether maybe there's some matters to degree, but sometimes when you're going through the steps to quantify some kind of impact, whether it's a small amount or big amount, you're doing the calculations. So oftentimes, just because it's a large amount of water or a small amount of water, doesn't always in itself change the, like orders of magnitude, the amount of resources it takes. We certainly identify those. So maybe in the general sense, that isn't a huge difference in the amount of resources we may take on that. Really, where our resources come in is if we have to actively engage and stay part of the process for a long duration, and particularly if we get in as an opposer and have to get the Attorney General's office engaged, there's some additional cost to us to have to contract with them to represent us in those cases. So those are impacts on our financial resources, but also just on our human resources in terms of all the other things we have to get done. The more active we are in any particular case, obviously, is going to take away potentially from, and we've heard these comments before about, should we just be out there making sure things are being administered day in, day out? And is that suffering in any way because of what role we may play in the water court process? So, and maybe I haven't totally answered your question or the comments you made, so if you could add to that if I missed something. So you're suggesting that in that initial phase in consultation, somehow identifying who those impacted parties are, making potential impact to them to the extent we have adequate information to do that. And then as that plays out through the process, the state could intervene later, post in that case, if they felt that those issues weren't being addressed as it relates to those small users out there. Is that fair? And I'm sure there's probably maybe some other questions. Let me just wrap up another couple of questions or thoughts here to get some input. These are maybe not necessarily the somewhat related water court process, but maybe a little bit outside that. I'd like to get some comments on this because we've been engaged in this a little bit. But What's folks' thoughts on whether the state division engineers should work with private engineering consultants to develop standard approaches for changing to water rights, augmentation plan modeling? We've been engaged in that a little bit. I know some of you here, the consultants, have been engaged with us in that process to some degree, but any other just thoughts that folks have of any that have been involved in that process? Do you think there's some merit in us collaborating, if you will, with the engineering consultant community on that? General thoughts? Yes.
I think I'd rather see you guys go through a rulemaking process where everybody can comment, rather than working with one consultant to develop your models or your policies. The policies especially frustrating because there aren't so much rules as there are guidelines, yet there's no way to get comment from everybody and actually hash that out.
Okay. Yeah, the suggestion was made that maybe the state should embark in an actual rulemaking process as it relates to maybe these engineering and scientific standards or whatever that we use as part of the evaluation, certain incentive use modeling. And maybe that since he raised that thing, kind of to my last question about those of you who are very familiar with our substitute water supply plan process that we're involved with, based on the questions raised there, do you think we should formalize that process through a rulemaking as opposed to the current process that's in place? Do you think that it needs to be stepped up to an actual rulemaking process to formalize that more than circumstance? Here's what folks' thoughts are on that.
The way I saw the final resolution of that was, okay, well, at some point the state set that, and this is what we decided. And that's the way I interpret it. What we do is certain farmers, but it allows everybody to be heard, and then it also just
Okay, the suggestions made that the rulemaking would be appropriate and it gives everybody more of an opportunity for input, and then the state would be certainly more guided by the specific rule that everyone's been able to weigh in and basically it's like a law, I guess it's out there that to some degree, and maybe it's not fair characterization, but when we have rules or statutes in place, those are oftentimes very mandatory to show things in a way. It takes maybe less discretion involved in that process. Maybe what you're suggesting that because of that, what may be perceived as more of a discretionary part of that process, that maybe that could be improved through a rulemaking process where more stakeholders involved. Yes.
Yeah, too many rules.
How much maybe we think we have too many rules? Yes. Come on. Evan?
That's why I question the premise that a standard approach is appropriate for us to hold one first. I understand why you would like to have maybe a standardized approach in your office and how you approach reviewing and improving the WFP. That makes sense. And that's what we are. Especially whether it makes sense for the state of the apply and help us on standardized procedures to apply across the state and all. This seems like that is not the right approach.
Yeah, Kevin commented he thinks it's maybe appropriate. The state wants to identify what their process is internally, how we evaluate substance supply plans and process for evaluating soil consumptive use and those things. That maybe that's appropriate, but to the extent we would want to try to identify the standards as they apply to the water court process that somehow would apply to everybody. That's probably not appropriate. And we've heard that. Those who've been engaged in this thing, we certainly feel that that's not appropriate either. We think there probably still are some opportunities to the extent if we're going to be engaged in the water court process to the degree that on the at least engineering scientific principles that the state division engineers and the engineering community are on the same page, if you will, certainly is going to lessen instances where we think we have to get into a case to argue something that we think maybe is an inappropriate method, for example, or parameters that we use. So we still do believe there's some opportunities to work there. Maybe it's not trying to establish standards, but to the degree there's some consensus on, like for, we use blended griddle or pin and run tea, or, which particular type of models are appropriate in what cases for changes of water rights. I think there may be some merit, at least trying to develop some general understanding to that. And we're continuing to work through that process. We're going to talk about that a little bit. One of the panels that's coming up, we'll touch on that a little bit in the third panel here. But given where we're at on our time, why don't we get started into our next session?